Hi, everybody. Thank you so much for having me. My name is Lauren Kirchner. I'm a reporter previously of ProPublica. I now work at a new startup called The Markup. Just a very, very quick introduction, and then we're going to get started on this panel. We're going to have David Levine talking about algorithms and agencies, Aaron Shapiro talking about smart cities, and Natalie Ram talking about forensic evidence. And then we'll have some questions.
Thank you. Thank you, Kathy, Rochelle, Engelberg, NYU, for putting on this conference, which is something I was super excited to see coming. I started writing about this train wreck of trade secrets and public infrastructure back in 2006 when I do presentations at IP conferences where people would say, first, what's a trade secret and what's the connection or whatever else. And slowly there's been this kind of nerd development around trade secrecy that culminates really in a conference like this. So I'm very grateful. And this is not the first trade secret conference that NYU's hosted over the last several years. It's great to see old friends meet new people here as well and make it through the atrocious 6 inches that locked up NYC DOT yesterday, but I got here this morning. So Rochelle kind of asked me to kind of give kind of like broad strokes, potential solutions to this very vexing problem as part of my presentation. So I thought what I'd do is kind of expand a little bit beyond trade secrecy, but tie back to these core issues of trade secrecy in my presentation. It's based on an article that was published last year in Tulane's IP journal called Confidentiality Creep and Opportunistic Privacy. But it really builds upon a lot of work I've done around trade secrecy, public infrastructure, transparency, and having a granular understanding of when we actually need trade secrecy and when we don't. In other words, when should the public or regulators have access to trade secrets without defeating the utilitarian justifications that require trade secrecy in the first place? We're all familiar with the Facebook scenarios that have occurred over the last few years. This is a tweet from earlier this year as the Russia connection was being made public. Still, there are key facts about the Russian actions that are still not well understood, and understatement, fast forwarding, right, to work that Epic has done, really amazing work that Epic has done trying to get their hands on the unredacted versions of the FTC required assessment reports involving privacy and data handling with Facebook. I found this to be particularly amusing. This is a document that Epic posted. The redacted portion of the page from the 2017 report that notes, you might note, the FOIA exemption for trade secrets, right above transparency, consent, access, use, and deletion. This is really nerdy trade secret humor, but I throw it in there. It kind of sets the stage for what I want to talk about today, which is thinking about where the issues associated with trade secrecy being a very broad brush for information control has led us. And so there's a couple of terms that I coined in this article, by the way, building upon, it's already been mentioned today, work that I did together with Frank Pasquale. So in fact, opportunistic privacy is really his phrase that he has allowed me to use, by the way, in this piece, particularly for the copyright people in the room. Confidentiality creep, the quiet, under-scrutinized, amorphous expansion of the kinds of information deemed inappropriate for public consumption. Privacy, this related doctrine to secrecy that doesn't get connected as much as it should, perhaps, but certainly has been connected today, which I was happy to see. Dubious use of privacy law and principles as an information control tool. Of course, we know what a trade secret is, but to fit it within this scheme, information valuable because it is not known by a competitor. Right? And how does it connect to algorithms, which Charlton Gillespie has referred to as network socio-technical assemblages? The result with regard to algorithms, and I'm going to expand a bit to kind of see how algorithmic computing is impacted by trade secrecy by talking about some non-algorithmic examples, results in information being captured and controlled at all levels of interaction, from the creative, the political, to the regulatory, to the social. Private, secret, confidential, and proprietary documentation, document labeling, and so forth have become semantic tools for minimizing information access, impacting civil society, government, professions, the public, but very importantly, also competitors. And the existence of competitors around trade secrets is what makes this a particularly complex area to solve, because information that the public may want or regulators may want for purposes that we've already discussed today, understandability to accountability, runs into a major problem when competitors can get access to that same information and engage in competition that from a policy perspective we reject. And so solutions become particularly challenging to solve, but that's what we're going to talk about here. The range of impact is from surveillance to voting machines to hydraulic fracturing. And my entree into this area was upon leaving practice here in New York as an IP and trademark litigator. I went to Stanford to work for Larry Lessig and Jennifer Granick as a fellow at CIS. And the first thing I ran into was this weird situation involving a vulnerability in a router that Cisco had created, and the person identifying that risk being threatened with trade secret litigation rather than being thanked for sharing this vulnerability with Cisco, which was a head scratcher for me until I realized that trade secrecy was very much standing in the way, quickly getting me into voting machines. This is an issue that is not well recognized or well understood, although today's conference may actually change that. And for that, I think we owe a debt of gratitude to NYU. Trade secrecy is used to control access to information. And I tell my IP students this regularly. When you're thinking about access, this is by far the most powerful IP doctrine that exists, because we're not focusing on use necessarily, but access itself. It impacts competitors, regulators, professions, security researchers, and the public. And the example I want to use, which is not an algorithm per se, but involves a formula, right, which involves the kinds of complexities that we see with algorithms, is greener technology through trade secrecy. Hydraulic fracturing, or fracking, which I think has been an issue here in New York a bit, if memory serves, is a technology where you have one of the paradigm trade secrets operating. The formula for the chemical being used in hydraulic fracturing is almost a classic definition of a trade secret. And so I am not a chemical engineer, but right down here, this horizontal drilling is where fracturing actually occurs. And there are risks associated with this behavior, environmental health and safety, that are generally only known if you actually have the formula. If you can assess the formula itself, the concentration as opposed to the amalgam of chemicals, that's where the EHS risks might in fact exist. The challenge becomes, right, what do you do when you have this trade secret in place that is required for access in order to understand the risks, when you have a company saying, but I want to create greener technology, and I will not create that greener technology if I have to reveal my trade secret. And this issue came up in one of the panels earlier today. It's a hard issue, because while the public might be served by a technology, do we want the best technology that trade secrecy would allow? Or will we go with an okay technology, maybe not the best, right, while sacrificing the trade secret for public consumption? The challenge becomes whether, in fact, that which is designated as a trade secret is, in fact, a trade secret in the first place. And there's lots of reasons to think that there is a wide brush being used, labeling lots of information as a trade secret, when, in fact, it is neither trade nor a secret, and perhaps shouldn't even be under that category. So I'm kind of throwing out and spitballing some solutions here, okay? Here's a great example of how this issue arises. When, in fact, Baker Hughes, one of the major chemical manufacturers around fracking, talked about the potential of revealing their trade secrets, they took a position that said, not surprisingly, right, the perverse consequence of impeding the improvement of hydraulic fracturing chemistry would occur if trade secrets were made public. And in fact, even to some extent, they made arguments that regulators shouldn't have access. But interestingly, in North Carolina, where I live now, North Carolina was writing regulations involving public access to fracking. And they approached me and kind of said, can you help us think this through? So it turned out that the former chair of the Mining and Energy Commission in North Carolina, a guy named Jim Womack, was one who wanted fracking to occur yesterday. However, was very concerned about chemical companies controlling access to information. And he took a very interesting position with regard to the regulation, which I think was profound and raises the challenge. If you're thinking about how you make the argument to a trade secret holder that perhaps they should be more transparent, consider the possibility that in the absence of sharing more information with the public or regulators, you cede the policy debate to your enemies. And that's exactly the argument that pro-fracking Mining and Energy Commission Chair Jim Womack made. If we allow, he argued, these Halliburton trade secrets, these chemical trade secrets, to be held secret and not be accessed by the public, the result is third-party organizations would control the debate, right? Which I'm sure everyone understands a third-party organization is an environmental group, okay? These are euphemistic terms. That's the kind of argument that seems to be very present and very effective when you're trying to deal with balancing the utilitarian interest against the public interest. And we see this issue arise regularly with technologies today. Autonomous cars get into an accident. One of the first accidents that occurred in Mountain View involving Google, okay? Position taken by Google. You, California DMV, do not need to see the data involving that crash because it creates a burden on you since you don't have existing engineering expertise to interpret the data. You don't understand it, so we don't have to tell you, okay? Now this is a few years ago, but this is where confidentiality creep builds upon trade secrecy and raises the odd theoretical argument, which I've never heard before, that you don't get to see information unless you can prove that you understand it first. A bit odd. Then you get to, right, our current situation involving Facebook and Russia. And you've got what I have termed in this article opportunistic privacy arguments. Arguments saying, well, let's protect the privacy, in this case, of our customers. But really what's going on below the surface is a reticence to reveal algorithmic information and decision-making processes around filtering that we would rather not share. We can't quite call it a trade secret. Maybe we'll call it privacy. Drones is another example of where this issue arises, right? The use of drones generally by the military, by civilian entities, and the like. Drones is really the first area, at least in my experience, where algorithmic computing confronted trade secrecy beyond, right, the voting machine. And what we started to see, particularly in an opinion called Maryland v. Andrews at the Maryland Court of Special Appeals, an understanding that we actually need to understand how technologies work in order to assess, in this case, Fourth Amendment interests. That doesn't sound profound, but in the broader context of secret information, to be clear, right, the technology being used here, algorithmic, trade secret, confidential, running up against a court's understanding that it actually needs to know more, is where we might see a future for balancing, again, the public interest against trade secrecy. This is one of my favorite examples involving Microsoft's effort to launch Tay, the artificial intelligence teenager, that because Twitter was trolled to become literally, right, a racist lunatic through the bot itself. For example, and these were organic results based upon this AI receiving input from Twitter. All right, so Tay tweets, yes or no, is Ted Cruz a Zodiac killer? Okay, the AI responds. You can find all of this out there publicly. Some people say this, disagree. Ted Cruz would never have been satisfied with destroying the lives of only 5 innocent people. Folks, I want to be clear about this. This is not my joke. This is the AI responding based upon data it received from Twitter users. This would be another example of algorithmic computing perhaps gone awry, but a reason for optimism. When Microsoft had to address this issue publicly, they pointed out something where I think, again, we see a future. What they pointed out was, in this sense, in understanding what we do with this technology, the challenges are just as much social as they are technical. So a second possible way to break through this vexing problem is to recognize that the sharing of technical data may actually be required in order to understand the broader sociological aspects of technology itself. And that's something that Ari Waldman brought up, I think, earlier today as well. Where does this all take us, right? One way to think about trade secrecy, coming back to the core of this problem, one way to think about trade secrecy would be go back to the fundamental basis for trade secrecy, which, as you probably know, is confusing in its own right. Is it a property right? Is it a tort right? Is it contract? Is it even necessary? This has been a debate going back at least now 25 years. One way to think about when we should reveal a trade secret might be to think about who it is that is actually asking for the material. So for example, and I'm not saying this is the solution, I'm saying it's something to think about, and this is the subject of the forthcoming article. If we focus on the property interest, the question of value in trade secrecy, we might say, has the value been diminished to the extent that a competitor is seeking the information? Compare that scenario with the other core element of trade secret misappropriation, which is the tort aspect of improper means and misuse, right? If you have a non-competing public entity, civil society group, regulator, then you might want to think about, is there an improper means here that would warrant, from a policy perspective, withholding the information? Notice what this gets to, and I'm out of time, I'll take this in one more minute. We need, another point, a much more granular understanding of trade secrecy and when it applies. The use of trade secrecy in algorithmic systems is radically different than the use of trade secrecy in the furniture business. It is also radically different when we think about it in terms of competitor accessing it versus civil society group versus regulator. As in most other areas, we have a one-size-fits-all trade secret doctrine. The passage of the Defend Trade Secrets Act at the federal level, which I will say, by way of caveat, I was a vocal and active opponent of, may lead to more granular understanding of when we need it. But where it gets us to, and I'll stop here because of the interest of time, we need to think very carefully about when we need trade secrets and when, in fact, the public's interest in accountability, in understanding, right, and ultimately in making decisions about the deployment of new technologies should outweigh the utilitarian interest in a trade secret holder. So I will stop there. Thank you very much.
It's tough to follow that up. I don't know much about trade secret law. I'm a PhD in communication, so a lot of this is new to me today, but very exciting. Thank you guys for having me here. This has been really great. When I was asked to speak, I was told 10 minutes to talk about, which is just to say that I was asked to talk about smart cities in 10 minutes. So that seemed like a big topic. So I kind of zoomed in on one particular case study, which I think might highlight some of the issues. It inflects with a lot of themes that have been coming up already today. And it's also something that I think a lot of you will be familiar with, the Link NYC kiosks that you see on the streets here in Manhattan and in other boroughs. So in 2016, Bill de Blasio celebrated the launch of Link NYC, New York's citywide public Wi-Fi network. And having been elected on a campaign to eliminate inequality, de Blasio praised the access that Link NYC heralded, bringing super-fast Wi-Fi to communities that needed it most, sort of a bridging digital divides kind of thing. And in the years since, Link NYC has been held up as an example of a successful smart city infrastructure, and as I'll talk about later, it's also been pointed to as a model for investing in smart city infrastructure. But it's also been challenged by privacy proponents and civil rights activists who've raised questions about the system's sensing mechanisms. Is Link NYC watching us? And if so, what is it doing with that data? Right? And these questions are actually extremely difficult to answer because the companies and the city agencies that have been involved have been pretty non-transparent about the data that the system is gathering and what they're doing with it. But what we do have are patents, because these are public. This is a patent for an invention called web level engagement and analytics for the physical space, and that's actually how it's titled. And what you're seeing here is a schematic diagram showing how a public Wi-Fi network can be turned into a surveillance advertising system. So this is how it works. A series of Wi-Fi access nodes or connection points, which are here shown as edge node 200, sort of right in the middle there. These are connected to digital signage, a content management system, and a registration database. The digital signage, sometimes also referred to as the public channel, displays advertisements in public spaces, train stations, malls, streets, in the case of Link NYC. And the content management system selects advertisements to be delivered to specific network points in locations at certain times and for variable durations. Then the registration database keeps a running log of activity around each network point. So how many people are near the advertising channels, how long they've been there, et cetera. And it knows this information because any Wi-Fi enabled device is broadcasting its MAC address, as in that thing up at the top saying, hi, I'm 012345. Any device that has its Wi-Fi turned on will be broadcasting this address. And the system just scoops up this information and keeps a record of it. So not only is it monitoring devices that are on the Wi-Fi, but also anyone who's walking by with their Wi-Fi turned on. And most of the time we just have that turned on. The registration database is then connected to all Wi-Fi access points and logs both users of the public Wi-Fi network and non-users, even people who are just passing by, right? So the goal is to generate audience profiles based on the information stored in the registration database. And the patent actually lays out how they want to go about doing this. According to one embodiment, if you can read that, according to one embodiment, the registration database provides an application programming interface, API, to allow other applications or systems to retrieve data from the database. For example, an application desiring information regarding a specific mobile user device or specific user can submit a request to the registration database for information on that device or user. According to another embodiment, information provided to a requester may be generalized. For example, if usage analytics are requested, the system may provide a general profile type of a user, urban man, age 30 to 40 with an interest in technology, rather than actual usage data. Also, according to another embodiment, access to the registration database may be provided in exchange for a fee. Additionally, in another embodiment, where two or more devices are discovered, the Wi-Fi access node may recognize usage data that is common to a group of identified users, also known as common denominators, and provide content to each one of the users relative to the common denominator. For example, if the Wi-Fi access node recognizes a plurality of users within the same location, each of which has a corresponding profile indicating that the user is interested in football, then the Wi-Fi access node may provide football-related content to the mobile user device of each user or to the public channel. So if you're on the network, it can throw things at your phone. If you're not, it can throw things up on the public channel. So the patent was submitted in October 2011, and its application was finalized in March 2013. And the initial assignee for the patent was a company called Control Group, but its current assignee is Intersection Design and Technology. And one of the authors of the patent is a guy named Colin O'Donnell, who's now the Chief Innovation Officer and Senior Advisor to Intersection. And Intersection is the lead in the consortium of companies called CityBridge that's managing Link NYC. So you'll note that in this complex web of partnerships and alignments, which is extremely complicated, so you'll see that Alphabet, Google's parent company, spun off Sidewalk Labs, and the Sidewalk Labs' first public move was to invest in Intersection, which is the lead in partnership with Civic Smartscapes and Qualcomm in CityBridge, and they manage Link NYC. This is this whole ecosystem. And Link NYC now is a network of public gigabit Wi-Fi kiosks, each with two 55-inch LED display channels embedded with at least 2 video cameras to capture activity around the kiosk. The advertising business is essential to Link NYC's business model and to its arrangement and franchise with the city of New York, because they're promising up to 50% of the advertising revenue to the city in exchange for a monopoly franchise. So it's actually interestingly, it's the payphone franchise that CityBridge took over. And as of '96, when they passed the Telecommunications Act, there were 39 telephone companies operating the payphones in New York City. And then as of 2014, when the next franchise began, it all went back to a monopoly, which is the CityBridge. So I guess what I'm trying to get at is that Link NYC is a near perfect embodiment of this invention. And in this context, what web-level engagement and analytics for the physical space means is a sort of translation of the kinds of tracking and monitoring that we expect in online spaces and that Google's really pioneered into the physical realm of urban public spaces. So you can kind of see there's a little tailored advertising here based on location. Here you see a partnership between Shazam and Link NYC, and a promotion for Coors Light. And when the system first launched, there was a number of concerns expressed about the privacy policy. The New York Civil Liberties Union filed a complaint critiquing its lax regulations on data usage and retention, as well as the company's willingness to hand over surveillance data and video to law enforcement. And eventually, CityBridge revised its policy, which I think is still in place. And it prohibits the companies involved from storing users' browsing history and sets a retention period of 60 days as opposed to, I think, 12 months as it was originally. But even in this new and relatively more stringent policy, there's little that sort of restricts what Intersection and the other companies can and can't do with non-identifiable information like MAC addresses. And this is where the patent comes in, sort of as a useful way to fill in the gaps in our knowledge. So just to give you a little bit more of a sense of what the patent wants to do with your information. The profiles stored in the database may also be augmented by information available through public sources or from a third party via the external network. For example, a profile stored in the registration database by a Wi-Fi access node of a retailer, so not the Link NYC network or the Wi-Fi network, but let's say Walmart's Wi-Fi network. And so they have your MAC address, which is related to a specific mobile user device and user, and may be updated via the external network to include prior purchase information from another retailer or list of other locations visited, as in sensed by other Wi-Fi access nodes. So all this is sort of saying that Link NYC has this patent under their sleeve, and they can and probably are selling data to third parties. We don't know. There's been a lot of work awesome work by investigative journalists, including that Ava Kaufman article that I cited earlier. And people are really starting to poke around and see what they can figure out. There's also an activist group that goes around and puts stickers on the cameras, and then those kind of get taken off every week by the companies. So what does this have to do with trade secrets? Well, it seems to me that what we don't know is the sort of algorithmic recipes for building those user profiles out from the really bare bones data that's scraped from the MAC addresses. It's really just timestamps and location. And they have another, the whole patent just has all these examples where they could infer things. And so, as in one example, it's like a guy who comes by a kiosk every morning at the same time, and when he shows up late a couple days, it starts to say like, oh, changing your schedule, Jim, or whatever, like this kind of thing. So profiling, I think, is the secret sauce of this web-level engagement in public space. And to me, this becomes especially problematic for a number of the themes that have already cropped up today. So I don't know how to talk about these things because I don't have a good enough grasp of trade secrets. But like, what does it mean for a monopoly franchise with no competition in the market to make claims to a trade secret? There's been no impact assessment around profiling because of this secret sauce sort of thing. And then there's the issue of mission creep, where the sort of like inferential profiles could be handed over to law enforcement. There's stipulations about the camera footage that can be handed over to law enforcement, but nothing about a profile that they are inferring based on the usage data. But another issue is that Link NYC is now being held up as a model for smart city infrastructure investment in general. This arrangement, the partnership between the City of New York and the City Bridge companies, prompted Deloitte to pose it as like a replicable kind of investment model that other cities could use when partnering with private companies to do infrastructure development. So I'm going to show you a made-up word. I've been thinking about this concept, and I can't quite put my finger on it, and maybe you guys can help me think about it. This notion of publicacy as opposed to privacy as a way to think through like an evaluative criterion for thinking about the arrangements that cities are making with private companies. And I'm bringing this up because I want to think about a way in which we can sort of, like a collective right to not be profiled is the biggest thing. And I want to think about it in terms of collective rights as opposed to an individual right not to be profiled, and what conceptual language we have for that. So thank you. That's my talk.
Okay. I am not that tall. I'm just going to be that tall. We'll just put it over here. Can you hear me okay? Okay, great. All right, so I like to start with stories, and I have several of them. So come along with me, and let me tell you about trade secrecy in the criminal justice space, some of which has already been mentioned, but there's a lot more to tell. So in 2015, Billy Ray Johnson was sentenced to life imprisonment without parole for a series of sexual assaults and burglaries that he says he did not commit. The primary evidence in the case consisted of DNA traces found on items from 3 crime scenes, including a phone, clothing, and a zip tie that investigators believed had been used to bind one of the victims. In order to link Johnson to the crime scene DNA, investigators relied on TrueAllele, which is a privately developed and privately owned software program for analyzing DNA mixtures that typical DNA analysis cannot resolve. Yet when an expert witness for Johnson sought to examine the source code for TrueAllele, she was rebuffed. TrueAllele's designer, Mark Perlin, steadfastly maintained that the source code is a trade secret, and Perlin refused to make the code available for review even when Johnson's attorney offered to sign a protective order. The judge in the case, meanwhile, refused to order that the source code be disclosed, but the judge did admit the DNA analysis that TrueAllele generated into evidence. In sum, what that means is that none of the investigators, prosecutors, defense attorneys, or even the judge in Johnson's case were permitted to access the source code of the crucial software that provided the key evidence in the case. Indeed, to date, no one outside of Cybergenetics, which is Perlin's company, has seen or examined the source code. And yet, largely based on that DNA analysis that TrueAllele generated, Johnson was convicted. Now, that's not the only recent example of the criminal justice system relying on privately developed tools shielded by assertions of trade secrecy protection. Instead, the use of trade secrets to inhibit disclosure of technical information pervades the criminal justice system from investigation to trial to sentencing. So in the investigative space, we can talk about the case of the Stingray. In March 2016, the Maryland Court of Special Appeals, you saw a quote from the decision of that court up here just a short while ago. The Court of Special Appeals became the first court in the country to hold that police cannot, without a warrant at least, make use of what's called a Stingray device.
The Stingray is a cell site simulator, which allows police to track a cell phone with near pinpoint accuracy in real time. It operates by mimicking a cell phone tower, forcing all nearby phones within its range to provide it with identifying information. Baltimore police had used a Stingray device in that case, a Stingray device called Hailstorm to track Karen Andrews to a particular residence where they arrested him on charges of attempted murder. Now, in order to obtain the Hailstorm device, the Baltimore PD had to enter into a non-disclosure agreement with the FBI, agreeing, among other things, not to disclose the use of the Hailstorm device, even to a court, even if it meant dropping charges altogether. And the Harris Corporation, the private company that manufactures and sells the bulk of the Stingray devices, including the Hailstorm, initially secured the cooperation of the federal government, of the FBI, in preventing disclosure of these devices, based in part on their valuable proprietary information. That is, their value as a trade secret. There's also an expansion of trade secret protected technology to generate evidence to be introduced at trial. The story of Trulio fits here, but so does more prosaic technology, like alcohol breath test devices. As with Stingray devices and Trulio, manufacturers of breath test devices have strenuously resisted efforts to make information about their devices public, or even accessible to criminal defense experts. For instance, Draeger, I think I'm saying that right, which manufactures the Alco test, one popular breath test device, has refused to sell its devices to non-law enforcement individuals for independent testing. And they've asserted trade secrecy as to the source code. In criminal cases, CMI, which is the manufacturer of the Intoxilyzer, you've gotta love the names here, which is another common breath test device, has repeatedly refused to disclose the source code for its devices, also on trade secret grounds. Now, most of the time, what's perhaps most shocking is that most of the time this assertion of trade secret prevails. In fact, courts have repeatedly vindicated manufacturers' trade secret claims either directly or indirectly by refusing to grant defendants access to source code in breath test devices. Now, in some cases, we have the most experience here, courts have explicitly just deferred to manufacturers' assertions of trade secret protection. The manufacturer says, this is a trade secret, and the court says, oh my God, it's a trade secret, no disclosure. It's as if they've never heard of a protective order. And in many cases, they haven't. They're working in criminal cases rather than civil cases. In other instances, courts have denied defense discovery requests with respect to the source code of a breath test device on grounds that the state is not in possession of the relevant code and so can't disclose it, right? You could get it if only the state had it because you have discovery as against the state, but the state decided not to demand it, so they can't give it to you. Sorry. Right? Finally, as we've heard already today, proprietary algorithmic tools have also come into use at sentencing. And here I can tell you the story of Eric Loomis. In July 2016, the Wisconsin Supreme Court affirmed his 6-year sentence of imprisonment, despite the fact that his sentence was based, at least in part, on a recidivism risk score generated by software whose source code was, you guessed it, not disclosed on trade secret grounds. Loomis pled guilty to fleeing the police and driving a stolen car, and the trial court's pre-sentence report included a recidivism risk score generated by the privately developed proprietary program called Compass, and Loomis was deemed a high risk of committing another crime. Now, Compass generates recidivism risk scores based on information in a defendant's criminal file and an interview with a defendant. And the company that distributes Compass, Northpoint, will disclose the questions in the interview, the questions that go into its proprietary software program. They won't disclose, however, the formula that they use to weight various factors to generate the recidivism risk scores. Compass was originally designed to aid the Department of Correction in making placement decisions, managing offenders, and planning treatment. It wasn't designed for use at sentencing. In fact, the user manual says, hey, don't use this for sentencing. But guess what? We're using it for, courts are using it for sentencing. And that's the case despite the fact that, as Lauren's excellent work has demonstrated, the software is racially biased, generating higher recidivism risk scores for Black Americans than for similarly situated whites. And yet, the Wisconsin Supreme Court okayed the use of Compass scores in sentencing so long as they're not the only factor that the judge identifies in sentencing. Now, in each of these instances, we have defendants, their attorneys, and sometimes even the judges in whose courtrooms innocence, guilt, or imprisonment is determined, operating at an informational disadvantage because of these assertions of trade secrecy. And reliance on trade secrecy in the development of criminal justice tools, I think, imposes real harms on the criminal justice process of both practical and potentially constitutional dimensions. So I'll say just a little bit about that, and then I'm going to save my potential solutions. I'm not going to talk about them here. I'll talk about them tomorrow. You'll just have to wait and see. Okay, so on the practical front, practical harms of trade secrecy in the criminal justice space, shielding criminal justice technologies from disclosure, I think, threatens to stall the development of effective and appropriate technology, which is to say, as others have said, right, well-designed and well-tested algorithms are better, right? Well-tested and well-designed algorithms may indeed, maybe, advance the cause of criminal justice, right? Perhaps making the impenetrable interpretable, or shifting aspects of decision-making from more to, well, hopefully, less biased data sources, right? But a lack of transparency and therefore an inability for defense counsel and others to verify or validate these data sources and algorithmic design choices makes even the best designed algorithm problematic. Access to source code, training data, and other similar information is often essential for a defendant to fully interrogate the algorithms that have led to their arrest, conviction, or sentence. And indeed, in the cases where defense counsel has secured outside expert evaluation of proprietary source code, those experts have repeatedly identified algorithmic weaknesses and outright errors in the code. Outside expert review of the source code of New York City's FST, a probabilistic genotyping software package that was developed and used by New York City, concluded that, quote, the correctness of the behavior of the FST software should be seriously questioned. New York City no longer uses that software package. Similarly, access to the source code for an intoxilizer model that was in use in Minnesota revealed that a deficient sample report could indicate a software failure. And based on that information, the Minnesota Supreme Court affirmed a categorical exclusion of these reports, absent other independent evidence indicating that a software error was not at fault. And when source code review of Draeger's ALCO test in New Jersey revealed that something called catastrophic error detection had been disabled, that seems like a problem in my view, the state Supreme Court ordered the company to turn catastrophic error detection back on. Indeed, the New Jersey Supreme Court required other firmware changes, and then including that the manufacturer be able to alter the device software and including that only the manufacturer be able to alter the device software, not that just anyone in the state could go in and mess around with the software, right? And excluding state coordinators who otherwise had access to the source code. In fact, the New Jersey Supreme Court, in ordering these changes, then allowed the devices to be used and actually observed that having now vetted the software and ordered changes to make it more reliable, that the public could then have greater confidence in its ability to accurately report alcohol breath levels. So I think there are problems of in a lack of access to code giving rise to worse code and also undermining public confidence in these kinds of tools. Now on the constitutional front, as the Maryland Court of Special Appeals recognized, secrecy surrounding the mere existence, much less the use and function of criminal justice tools, can interfere with defendants and courts' efforts to ensure that the government doesn't engage in unreasonable searches in violation of the Fourth Amendment. And I think the use of trade secret shielded technologies to generate evidence admissible at trial also generates tensions with the due process clauses of the Fifth and 14th Amendments. So here I want to just identify places where trade secrecy at least butts up against or is in tension with core constitutional commitments. The due process clause, or the due process clauses, right, guarantee every individual the right to due process of law, and the Supreme Court has explained that this guarantee affords criminal defendants a meaningful opportunity to present a complete defense. That right encompasses a defendant's ability to impeach witnesses and impeach the evidence that the state may introduce against him. And where that evidence results from the use of algorithmic tools, the surest and perhaps only way to thoroughly cross-examine this kind of evidence may be to review the source code of that criminal justice tool. And maybe not just the source code, also the training data and all the other things that our earlier speakers have identified as relevant. Now, the Due Process Clause also establishes minimum fairness standards for sentencing. The Supreme Court has made clear that due process guards against sentencing based on materially false information that a defendant has no effective opportunity to correct. And the court has similarly suggested that sentencing a defendant on the basis of confidential information which is not disclosed to the defendant or his counsel can run afoul of due process. In other words, due process is intended to ensure that a sentence derives from accurate facts. Now, if a sentence is based even in part on a recidivism risk score determined by an unsound algorithm, that amounts to a sentence based on an inaccurate fact. And that's so despite the fact that North Point, which manufactures the COMPASS program, right, discloses the informational input for the program, right? But because that doesn't guarantee that the scores that COMPASS produces, based on its proprietary weighting of that information, will be valid. And the inability to ascertain the reliability or validity of the methodology underlying COMPASS's risk scores runs counter to the due process principle. Indeed, no less an authority than the Solicitor General of the United States conceded, against his interest, perhaps, that a court's use of a risk assessment based on an undisclosed scoring methodology creates at least the possibility not only of scoring error, but of a flawed actuarial approach that a defendant cannot effectively counter through other types of evidence. Indeed, the Solicitor General acknowledged that some uses of an undisclosed risk assessment algorithm might raise due process concerns. Thanks, Mr. Solicitor General. Now, finally, the Constitution operationalizes its concern for fair trial procedures through a variety of Sixth Amendment criminal defense rights. Of these, the Confrontation Clause has received the most attention in this arena, and here I really apologize that you're stuck with me and not with Andrea Roth, because she's written the best article I know on this topic. The Confrontation Clause affords the criminal defendant the right to be confronted with the witnesses against him, and as Professor Roth argues in a recent article, machine sources sometimes may indeed trigger a right of confrontation. The Supreme Court has informed us that the principal evil at which the Confrontation Clause was directed was the civil law mode of criminal procedure, and particularly its use of ex parte examinations as evidence against the accused. Professor Roth elaborates that the chief danger of such ex parte statements was that they were impressive looking, but unconfrontable, leaving defendants with little chance of disputing them. And unfortunately, as she explains, allowing the state to build or harness machines to render accusations without also providing the defendant a constitutional right to test the credibility of those machine sources resembles trial by ex parte affidavit. A lab analyst or law enforcement officer reports the results of an algorithmic process, like an individual reading an ex parte affidavit into evidence. That witness can't speak to the underlying accuracy or reliability of the report they read, not fully. And yet that report, like an ex parte affidavit, is surely impressive looking. On this view, the defendant's right to confrontation should encompass the opportunity to impeach the machine source itself. Cross-examining a software developer is not a suitable substitute for examining the software source code itself or its training data, because code will never exactly embody a developer's intent. Errors can arise from coding mistakes or software rot, of which a developer is unaware, as well as from predictable false positive results. And so assertions of trade secrecy conflict with constitutional principles, here the right of the accused to cross-examine his accusers. In sum, assertions of trade secrecy interfere with defendants' ability to vindicate their due process and confrontation rights at trial, their due process rights at sentencing, and they also hamstring defendants and courts alike in their efforts to ensure that the government doesn't engage in unreasonable searches. Indeed, regardless of whether these trade secret-related difficulties rise to the level of independent constitutional violations, and I think there's a good reason to think they may, right? But even if they don't, they certainly make plain that trade secret assertion in the criminal justice space exists in tension with these bedrock constitutional principles. Thanks.
All right. Thanks, guys. Oh, so many computers. Okay, so I have only 1 million questions for you, but I know people in the audience probably have some questions too, so I'll just start with one or two. This has been so interesting to me to be here because I think a lot about transparency in government. As a reporter, it's, you know, my ability to do my job depends on access to information. And it seems to me that there's really a trend towards privatization in what were once government services. And with that privatization comes a lot of, you know, confidentiality creep. There's lots of examples of businesses competing to be vendors for agencies, but there's also sometimes cities will compete to attract business from companies. And I know, David, you've written a little bit about how privacy and confidentiality can sort of be like a deal sweetener for cities. We saw in Amazon's shenanigans that the officials from the final cities competing for Amazon's business all had to sign NDAs. I know that this is something we're going to talk a lot about tomorrow too, but I'm just really, I have to ask what you guys think some solutions are. We've heard a little bit this morning about, you know, model protective orders, algorithmic impact assessments. Occasionally we'll read, you know, an op-ed saying, you know, I saw a headline the other day, we need an FDA for algorithms. Sounds great, but I have no idea what that looks like. So I'm curious to hear from you guys, whoever wants to jump in. What does transparency look like ideally if we were to imagine an ideal situation when it's government agencies and companies teaming up and making these kinds of deals? What does regulation look like? Any ideas you have about that?
So if I recall correctly, in the fallout after the New York City's abandonment of the FST software, New York almost created for New York City, not the state, just the city, almost created for itself sort of an FDA for algorithms. There was a bill on the table that was going to create kind of an agency that was going to review any algorithm that impacted city citizens and try and test it for validity and reliability, and said nothing about trade secrets, and that almost happened, and then it got replaced by a much watered down bill that actually came into, that did get passed, that basically called for like a report on how algorithms are being used, and maybe we'll do something, but we definitely won't interfere with proprietary claims, including trade secrecy. So almost, but not.
I mean, just with the idea of something like Link NYC becoming a model for how we think about financing infrastructure in cities, yeah, I mean, the idea that you can like just build that on the backs of, you know, covert surveillance-driven advertising and surveillance capitalism, to me sounds like an incredibly bad idea. What was the term that you have in your presentation that was the sort of like misuse of privacy policies?
Opportunistic privacy.
Yeah, I think that's really at work in a lot of these things where it's like the non-identifiable information is it's good enough for us to sell, you know, push promotions to you in this way.
So if I could just have a follow-up on the Link NYC, what of the data that's collected by those kiosks, what data is available? I'm just so curious. Like, what is the relationship between the cities, between the third-party vendors and law enforcement, for instance? Is any of that stuff FOIA-able? Can I get at any of that stuff?
It's I don't know. I think that with I filed a FOIA request with DoIT, the Department of Information Technology and Telecommunications, which is the city agency that actually did the contracting with the Link NYC people, and that was pretty forthcoming. But it wasn't any specific data about people. It was had to do. So there was before Link NYC, there was a whole design competition. And so sort of I was trying to get after like what were the other designs that were out there that they didn't consider. The specific data on people, I can't imagine that they would hand that over because it's proprietary. It's how they make their money.
Yep.
I mean, it's a huge challenge. Lauren, I think, so a couple of broad thoughts. First, I mean, whether you're dealing with breathalyzer machines or city wireless programs and other efforts to connect the public, or you're dealing with voting machines or fracking recipes, one broad issue, which you've alluded to, is generally regulatory capture, right? So to the extent that you have agencies, right, that are vested with the power to regulate in these spaces, right? I mean, Alfred Kahn wrote about this 40 years ago, right? The inherent interest within the agency is to work to some degree in tandem, right, with the agency and vice versa. And so the agency in that way becomes captured. This is why from the get-go, working on this issue, starting with those routers to voting machines and on forward, I've been very concerned that we lack the regulatory apparatus to push back against that, such that the public needs greater access to trade secrets. So that's number one. Number two, as far as solutions, and it's difficult to say this post-election day, but we need to be electing public officials that have an understanding of technologies. I wrote a piece several years ago for Cardozo's Arts and Entertainment Law Journal called "Bring in the Nerds" about SOPA, and that wasn't my phrase. That was former Utah Representative Jason Chaffetz's phrase in SOPA hearings, where he said outright, "We don't know what we're doing here." And so Mark Lemley and David Post and I wrote a piece called "Don't Break the Internet." And my motivation in part was we are not regulating correctly because we don't understand the technology itself. That says nothing of the substantive merit of a given solution. In trade secrecy, that problem is exponentially greater because of the complexity associated with assessing whether a trade secret should exist. And I have enormous sympathy for this issue because in order to understand whether in fact an industry requires a trade secret in order to maintain its competitive position, you need to understand the industry. That industry may be hiding information directly, may not want to share it because of competitive issues, and so it becomes, right, a form of Auer's information paradox. And so you can't ever get the information necessary to assess whether the claim of trade secrecy is appropriate. So that's a third issue, actually. The fourth one I'll suggest, and I've made this point before, is that perhaps particularly where we're engaged in public infrastructure projects, we need to have a general understanding amongst the public and certainly regulators that the privilege of serving the public means you will give up some proprietary information for the greater good. Now, I'm putting aside all of the political constraints associated with that and being able to do it, although I try to suggest in my presentation ways to make the arguments to industry as I have, and have had some success in getting industry to understand that it is in their better interest from an innovation standpoint to share. So those are kind of the broad challenges associated with these issues, but quite frankly, I come back to two fundamental problems. We have capture going on at the regulatory level, and we lack expertise inside government.
I want to just piggyback on that with a slightly more sunshiny perspective, a little bit in the solution space, which is that when we're talking about algorithmic tools in public spaces, criminal justice, smart cities, or agencies, or elections, right? We're talking about kind of monopsony buyers, right? So, there's only one New York City. Everyone wants to serve New York City. There's a lot of cities out there, but basically these kinds of tools are being developed for public entities. And so that gives the public entities a little bit more, I think, kind of bargaining power in that space because you might have several companies competing to serve a single buyer or a limited set of buyers, just, government buyers. There's fewer of those than there are individual people.
Okay, individual people leads me into my next question. But while I'm asking this, if anyone in the audience has any questions of your own, if you'd like to approach the mic while I'm asking this, feel free. But I wanted to zoom out a little bit and take this out of the courtroom, out of the classroom, into the real world. What do we know about how the public's attitude towards this type of technology has changed or developed over time? Or actually, well, we could stay in the courtroom also, looking at judges and juries. You know, do people hear a piece of evidence presented to them that comes from a black box algorithm, and do they think, well, a computer says it, it must be right? Or are people starting to get savvy now, and not just judges and juries, but you know, people walking down the street, having their photo taken by a kiosk in front of them, or whatever. Have they read about, you know, a scandal in Facebook and other higher profile algorithms, and are they starting to gain a kind of skepticism about these types of things? What do you think about the overall education of the public on issues like this?
Well, just briefly, like I think a trait of a lot of these automated and semi-automated decision-making systems is that it's supposed to come off seamlessly integrated into, like in the courts when they're using the risk algorithms. To what extent is that like presented as a separate piece of information as opposed to just like part of the logic that goes into a sentencing decision? I've studied geospatial predictive policing, and that the algorithmic use is not evident to, if you're living in a neighborhood that is being patrolled, you have no way of knowing whether that patrol is allocated based on an algorithmic output or not. It's sort of like just woven into the normal operations of the socio-technical assemblage, right?
Go ahead.
Yeah, you know, it's a great question. I kind of liken it to what I think the courts have been doing in likelihood of consumer confusion analysis and trademark, and that they're slowly recognizing that the level of sophistication of the average consumer is higher than they might assume. I only have anecdote data on this, but Facebook clearly has done enormous damage to its reputation by virtue, again, in part of secrecy. And I do think my sense is that there's at least a greater degree of skepticism with regard to what, in fact, technologies are doing in the absence of knowing about them. Having said that, the private ordering nature of the internet and algorithms being what they are, people choose to use them anyway, notwithstanding these blind spots because they see socially beneficial outcomes for themselves. So I'm dubious that we're going to have any, eureka type moment in terms of the public rejecting these technologies absent more transparency. As alluded to earlier, we really have to get to a finer understanding of explainability, and I second, or I don't know if Ari's still here, but I second his endorsement of Margot's article, Margot Kaminsky's article with regard to the GDPR. I think we have to ultimately decide whether, in fact, we have enough of a basic understanding of what these technologies are doing in order for the public then to be trusted.
Sure.
But I think courts are starting to catch up with the idea that the public maybe is a little smarter with technologies than they think.
So, so I think maybe there's growing skepticism, but I think also when it comes to criminal trials, you know, forensic science and I think specifically about DNA evidence is, you know, virtually uncontestable, right? And so what happened with the probabilistic genotyping software and the way in which that was first admitted into court was that basically trial courts looked at traditional DNA sequencing and DNA identifications, which had a reasonably good pedigree, right? It was DNA analysis and identification were kind of developed in science and then ported over into the criminal justice sphere, which is quite different from these probabilistic genotyping tools, which were not developed in, you know, scientific research labs. They were developed for use in criminal prosecution. And judges kind of said, well, DNA science is reliable. DNA identification is reliable. And this is just like a better way of doing DNA identification. So of course it's reliable and admissible and whatever. And that, you know, that understanding how traditional DNA identification differs from this probabilistic genotyping stuff requires a level of sophistication that I think it's really hard for ordinary members of the public and even judges to grasp.
Thank you, guys. Who would like to ask a question?
Hi,
Hello.
this has been a brilliant panel. Thanks so much. I was just thinking, this panel has particularly exemplified something through the morning, that we know a lot of what we're talking about has been reported out through the kind of stories that we hear in the media, and then we're picking up afterwards to deal with it, whatever opacity has been revealed. And this thing that confounds me in the Link case and in lots of the situations where there's an unevenness of bargaining power, I'm surprised that what ends up happening is that the representatives of the public interest don't stand up and say, oh no, we're fighting for you. They seem to retreat even more. And I wonder if it's partly the stories that get told, where if we gave more, I don't know, I'm just curious if you think there's sort of different stories we could tell, both about the sort of public side of some of these relationships, and also about the sort of regulatory possibilities. So you mentioned about the, prospect. There's plenty of, I guess the thing about them is that they're actually quite public, these possibilities for solutions, but we don't report on them in the same way as, like, Google says it's going to do a thing and then everyone reports it really enthusiastically. So we don't report, someone said we should have an FDA for algorithms, and it kind of gets reported with that same sense of possibility, I guess. And so it's just kind of that, I don't know if I'm quite getting at it, but this sort of difference in tone about what's possible. And similarly, when we then, look at this, terrible thing that a private company is doing in the criminal justice sector, it sort of buries the problem further as the more we report on it. And it's kind of like just interesting ways in which the openness and the secrecy, I think, then kind of lead to what solution space exists.
So, Jill, that's a great question. I mean, and again, I should say this. I mean, not only am I an enormous fan of your work, as you know, Julia, but ProPublica. And ProPublica's work reporting on these issues at a granular level is essential. I mean, it's truly a public service, and so we are in your debt. Let me say this. On the point involving advocacy around these issues, which I think is related to it, and I'm really trying to hew to trade secrecy, although it's a broader problem. My experience dealing with these issues over 12 or so years is that, as a general matter, because trade secrecy in particular is a doctrine that is not heavily studied, and certainly as compared to the other three IP doctrines, because we lack empirical data involving how trade secrecy is actually used. I have a piece with Ted Sitchelman that's coming out in a month in Notre Dame's Law Review on startups and trade secrets, which should not be the first piece focusing on startups and trade secrets, but it is. And it's not because the entire field has failed and we're the smartest. It's because there's not much data to use, and it turns out Berkeley had a patent study, and Ted was one of the authors of it. I wasn't. I'm a free writer. And we were able to mine the data. So one of a big challenge here is, in my opinion, is because it isn't studied closely, because it's a complex doctrine, because of the irony that to understand whether a trade secret designation is appropriate, you need to have access to trade secrets, okay? The result is, in the case of civil society groups who are pressed for resources to begin with, they simply don't have the people who have the time to focus on it. Now, Peter Maberduk at Public Citizen, I think, is a great example of someone who spent time in this space, and he focuses on access to medicine and issues like that. But they're few and far between, and I don't think it's for a lack of interest. I think it's for a lack of capacity.
So you actually may have preempted part of my question, but I was wondering, to what extent, if we have any data on it, do we see lack of understanding or lack of even knowledge that an algorithm is working, ordering sort of backdrop decisions? So in Ms. Ram, you focus a lot on trial context using all of these algorithmic decision-making devices. But of course, the vast majority of criminal defendants are sentenced through plea deals. Mm-hmm. To what extent do we see the influence of algorithms that may or may not be used at a trial, or may not be used in, say, the Link NYC context? We're not, all of our assumptions there are based on this patent, not on real data. To what extent do we see, like, people sort of working around algorithms that may or may not be as powerful as we expect them to be, but nonetheless are shaping decisions simply by virtue of people's imagination that an algorithm might be really powerful, rather than empirical study of the algorithm itself because of this opportunistic privacy model?
Well, so of course, even if you decide to plead, you will plead because the state tells you we've got this result from the intoxilizer that we would introduce at trial, which would demonstrate that you exceeded the legal alcohol breath or alcohol blood limit, right? And so, of course, plea bargaining always exists in the shadow of the evidence that would be introduced at trial. So I think it's still shaping decisions in that space. And then now I forget the rest of your question. I'm sorry.
It was just like, to what extent do we have any information about that shadow, other than just assuming that it's there?
I mean, we know that the vast majority of cases plead out. I don't have the statistical. I don't have any statistics on how many cases pled out under traditional DNA sequencing or identification methods as opposed to probabilistic genotyping methods. I suspect it's probably about the same because everyone hears DNA evidence and just thinks, oh, DNA evidence, right? And wow, it's the gold standard science. Even though there's reason for caution, both with traditional methods and with these new software methods. So I think I don't think we know.
And to that point, and Julie alluded to earlier, we have non-disclosure agreements and confidentiality agreements operating in the public sphere. I have a piece I've been working on for too long called The Private Ordering of Public Space, because we're allowing governments to enter into NDAs with private entities to prevent the public from knowing how governments have altered algorithms. And this has happened literally with voting machines. So that's an enormous impediment, because the only thing arguably stronger than a trade secret designation for purposes of public access is a properly executed contract. And the government our government, both at the federal and state level, have entered into these agreements in everything from international trade negotiations involving these kinds of issues right down to the county level.
I guess I'll just hold this up. Hi. Hi, Vincent Sutherland here at NYU Law. This has been a fantastic panel. I just had a couple of questions and one kind of point of slight clarification. So, Natalie, you mentioned that New York City has kind of put together a task force of some sort that I think started off, at least some of the impetus for the legislation that produced that task force started off maybe with more loftier goals that would have gotten at some of the concerns that come up in the DNA context. But what is, I think, grown out of it is something that I think holds a lot of promise more generally when we think about the use of algorithmic and automated decision systems in public agencies across the board, which is this task force that's kind of the first of its kind in the country, really designed to come up with a system and a scheme that will allow people to kind of understand like where these decision systems are making judgments in their lives, to figure out how to provide some measure of oversight and some concerns around implementation and the design of these systems, and also to figure out how do you challenge decisions when they're made about you. And so I happen to be a member of the task force, and selfishly I have a couple questions that are kind of within the scope of our work. One of which is, it occurs to me that often people don't even know when they're being judged by these systems. And so have any of you, or does anybody in the room, have any ideas of how we kind of educate the public about they're being judged by these systems in the first place? And then the other question is, to the extent that you're able to challenge a judgment made by the system, have you seen kind of procedures or processes that allow for those challenges to actually successfully move forward? Recognizing kind of the tremendous imbalance in resources between the individuals who's being judged and the kind of the system that's doing the judging, as well as these concerns around trade secrets that are, I think, a whole other piece of the pie that our task force, quite frankly, has not grappled with. But I think to the extent that we're making recommendations to the mayor that may eventually turn into legislation is something that I think we'll certainly have to take up, particularly when you think about the entities like the NYPD and others who are involved in using these automated decision systems. So take my answer from this.
Well, wow, this is an example of not knowing everyone in the room, and that's a bad thing. I'm sorry, I did not mean to insult the task force. And I will know that though the initial draft legislation would have been an even stronger first in the nation type of thing, the task force itself is still like a first in the nation, better than other cities are doing. So thank you. And thank you for your work on that task force.
We salute you.
Yeah. So I think it's really hard for people to know when decisions are being made about them, subject to an algorithm. It's easier perhaps when we're talking about the criminal justice space, or specifically about evidence being introduced at trial, because the accused has the right to know about the evidence to be introduced against him or her, and maybe where that comes from, at least to say, like, this is the software we use to produce it, but no, you can't have the source code or the training data, right, which is insufficient, in my view. I think it's a lot harder in the context that you guys are talking about, where we're talking about ordinary people on the street, right, who don't realize they're even being watched. But even that comes up in the criminal justice space when we're talking about software like ShotSpotter, which is used to figure out where a gun was fired from, or the location of a gunshot, or hot spotting technology, which is used to dispatch police based on historical patterns of where arrests have taken place. Unsurprisingly, it continues to dispatch police more to minority neighborhoods and poor neighborhoods than where police have historically spent a disproportionate share of their time.
A couple of quick thoughts on that. First of all, Kroll at Princeton wrote extensively on accountable algorithms, I'm sure you're familiar with, and there's been an effort to try to create that explainability that's been heretofore referenced, which I think, right, is an effective solution to the extent that simply notice that a decision is being made is better than nothing at all. And so that is able to protect the code, which itself would be a trade secret, as opposed to that something is happening, which could also be a trade secret, but which in the public sphere we'd say would be a stretch. The other thing to consider, and I'm not suggesting this is a perfect solution by any stretch, but I mentioned the Mining and Energy Commission in North Carolina. One positive thing that the regulations put together, and the regulations were problematic in other ways significantly, was to create an administrative process where the public could challenge a trade secret designation through a panel of experts. Now, admittedly, that is a classic access to justice situation, to the extent that a member of the public is going to hire an attorney to challenge an administrative understanding of a trade secret. But the process is in place. To my knowledge, it's not been used, but that's because fracking hasn't even begun in the state of North Carolina. But certainly in New York, where you've got more of this kind of activity happening, it might be a model. It's an expensive model. It's one that requires a fair amount of resources, but consider the fact that as a general matter, what I've found more recently is you have more and more administrative entities that are concerned about even holding a trade secret because of the risk of its accidental disclosure. And that's an issue which has come to the attention generally of many folks focusing in an area. Now, that's radically different perhaps than what New York City is doing. And New York City has a wonderful history of dealing with these issues, going back to voting machines themselves and the electoral process. But that might be a way to approach it. I'm happy to talk to you outside of this room about ways to address it.
I think we have time for one more.
Sure. One more. I wanted to bring up the idea of when someone has standing to complain. And I heard this coming up in the morning as well. So clearly there's points, as you were saying, the criminal justice system, or there's the very clear points. But there's also things like, I didn't even hear about a job opportunity. It wasn't advertised to me. It was advertised to other people. That's a little harder to, and then also the kind of, it's one thing if the GDPR we're saying is if they're making decisions about my private data or my private data is involved. But there's also when data about other people who write in capital letters or other women or other people like me, and they're still making decisions. And especially when it's problematic to say, do you want to submit to surveillance so that your data can go on record to be someone like me, or do you not want to? Those are pretty problematic issues, and I'd love to hear some of your thoughts.
I'm like a broken record on this. I'm dating myself now by referencing Vinyl, but those may not be trade secrets. And hewing to the topic of this conference, I urge everyone in this room who is interested in this issue to first probe the basic question of whether that which is labeled a trade secret actually is. And it doesn't have to be any more complex than this, and certainly journalists know this well. The FOIA request that's made, which subsequently winds up being mooted because the government launched it somewhere else, posted it somewhere else, someone else got access to it, rendering the administrative process moot. What I would urge folks to do at the first level, right, is to recognize the broad stroke use of trade secrecy as a catch-all for confidentiality, leading to this amorphous confidentiality creep and opportunistic privacy. The public, in other words, perhaps should be more skeptical about the designation. That's number one. Number two is to point out, and I suggest this, market forces. I do think that at least at the granular level, when you're dealing with folks that are trying to do the right thing, reaching out directly, if you can find them, to people and saying, I'm concerned about what I don't know about this technology, may lead to some candid conversations. Two minor thoughts, but I think potentially useful.
Just a quick follow-up to that. So if people are fighting a trade secret claim, what are they fighting for? Are they, is,
Right.
in that case, is someone trying to get the training data of a program so that they can learn, like, oh, I was rejected for this thing because I am demographically similar to these other people who have been found to yada, yada, yada.
Right.
Is that what they're trying to find, or what?
Well, if we use the classic standard definition of a trade secret, whether in the Uniform Trade Secret Act or in the Defend Trade Secret Act, as information that's valuable because it's not known by a competitor, right? The focus is competition, right? And where there have been efforts made, which have been more recently successful, to get access to this information either through FOIA litigation or generally, it's been hammering the point that there is not a competitor to this information. That doesn't mean that there aren't other reasons to maintain the secret. But, and I'm an embarrassment now, but Jonathan Maines, who's sitting in the middle of the room, knows this quite well with the work you've done in the past at Yale, trying to deal with these questions. And that's the kind of granular example that's needed. At the risk of making myself busy, I'm happy to talk to anyone who wants, God help me, who wants to have a better understanding of these issues from a public interest perspective, because in my view, as an academic, part of my job is educating the public, and we just don't get it. But recognizing, I'm getting back to the standing question, right? Recognizing that you might have an interest in information is not something that is well recognized in trade secret law because it focuses on competition. It doesn't focus on amorphous public interest that perhaps it should. And as my two co-panelists did great presentations pointed out, there seems to be a growing understanding among the courts that we might add this public interest issue into trade secrecy, even though, to be clear, for its entire history, that concern is utterly absent from the law, because trade secret law is not recognized as something involving things other than competitors in the marketplace.
I would also flag, Rebecca Wexler has a paper in which she talks about the evidentiary trade secret privilege and its pedigree, and she notes that in a lot of cases, at least in the criminal justice space, there's overclaiming of trade secrecy where there isn't a trade secret, and then there's a lot of overclaiming about the scope of the trade secret as well. And so if the courts adjudicating these claims of trade secrecy in the criminal justice space actually understood trade secret law, even if they just understood like ordinary trade secret law, we might get quite different results. Number one, because they might find there's no trade secret. And then number two, because even if they find that there is a trade secret, they would recognize that it is quite common, even when you're dealing with an actual commercial competitor, to order disclosure of trade secret protected information subject to a protective order, which a lot of these criminal courts, not having a lot of experience with trade secret claims in the civil context, the commercial context, they're just like, oh my God, I don't want to interrupt innovation, therefore you can't have anything, right? Which is, that can't be the right solution.
Okay, so potential area for a tiny bit of optimism maybe seems like a good place to end. Thank you guys so much. Great questions.